Alrighty, so this is Decent We the People News. Okay? I'm not an attorney, I'm not giving legal advice. None whatsoever, so do not take it as such, okay? It's my opinion, this is an educational video, okay? Why? Because we never look straight forward, we always look around us to be able to protect ourselves by any means necessary. Alright, so we got lawyers and all these people out there talk bad about challenging jurisdiction of the courts and how they're getting jurisdiction and all that kind of stuff. And they call them sovereign citizen and all that because the lawyers want you to divert away from that so you can keep using them. Because it has been case law that when you challenge the courts must tell you how they're getting jurisdiction. Okay, so it's not a sovereign citizen thing. It's not a sovereign thing. It's actually a law thing. It's legal, legalese, and lawfully. Okay? So, therefore, quit listening to these attorneys out there that's saying it's a sovereign citizen thing when it's not. They have their own case law saying to the judge they must tell you. Alright? Now, that being said, I found this video and it's talking about in realm jurisdiction, which we must know. Part 1, Part 2. Okay? Because we can do subject matter and all that kind of stuff, but what about in-realm jurisdiction? If you cannot challenge in-realm jurisdiction because you didn't know they're using it, then they're going to run you over. So we got to understand the in-realm jurisdiction 1 and 2. Okay? Let's proceed forward. By the way, part 1 is really more of a home foreclosure thing. Part 2 is your city and your county confiscating your land. So let's distinguish the two. Of course, I think he's going to do all that. So here we go.
To explain to him what legal fiction was, and it was interesting because, again, I found this great piece of just clear-cut information, and I'm like, oh, this perfectly fits everything that people are trying to figure out. So, unfortunately, I don't have screen share option on here, or I would screen share, but I recommend that anyone watching this video that wants to know about legal fiction, I highly recommend, number one, I always recommend definitions, but look up Cornell Law definition of legal fiction. You want to go on and find it on Cornell Law. So if you just type in legal fiction, Cornell Law, it'll come up. And it's very telling, extremely telling. So I'll read this real fast, and then I will explain a little further. So it says legal fiction is an assumption and acceptance of something as fact by a court, although it may not be. So in other words, they can accept a lie, right? A fiction. So as to allow a rule to operate or be applied in a manner that differs from its original purpose while leaving the letter of the law unchanged. So they can apply a rule in any way, okay, that differs from its original purpose while still covering their ass in the law. How convenient, right? A legal fiction is created typically to achieve such varied aims as convenience, not our convenience, obviously, consistency, equity, that's a big one, or justice, okay? Equity is what our ears peak up with, big time. Okay, so that's all well and good, very explanatory. We kind of know that. But the next paragraph, the example here, was like, oh yeah, this is right where it's at. So it says, for example, when a court cannot exercise in personam jurisdiction over a defendant, meaning they can't exercise jurisdiction in the person, right? The natural person, the living man, whatever you want to call it. It can bring that defendant under its jurisdiction via quasi-in rem subtype 2 jurisdiction. I got to tell you, I've been doing this 12 years, and I never heard of subtype 2 jurisdiction. I've definitely heard of quasi in rem, in personam, and in rem meaning in the property. But I never heard subtype 2, so that was interesting. So it says the latter, the subtype 2, quasi in rem subtype 2, is a form of personal jurisdiction. Right, so it's a fiction because they're saying it's personal, it's in personam, even though it's really not. That uses a defendant's property to satisfy a claim against them. So it uses a defendant's own property to satisfy a claim against them, and is a legal fiction because it treats the owner of the property as a defendant, although the subject of the suit is technically the property itself. Okay, so of course I said, well, I want to go to quasi in rem subtype 2. So the first thing it says, of course, is when hearing quasi. So I looked that up under you can actually just click on the link in Cornell Law under that definition, and it'll come right up. When hearing quasi in rem actions, a court may only affect a named defendant's interest in a specific named piece of property. All right. So these actions have similarities with both in rem and in personam actions. So again, when hearing quasi in rem actions, a court may only affect a named defendant's interest in a specific named piece of property. Well, what's the interest? In what property? The interest in the securities, right? The certificated security, the interest. They can only affect that. That's why it's so powerful when people are going in there and they're not allowing the attachment of the name, right? By saying, my name is John Henry, the House of Doe, or however you might say it, Family Doe, or, I'm not the person type of thing. They can't get jurisdiction because they can't attach you to the property. That's what they're doing. This explains it so well. I'm like, this is so perfect, man, how this is explained. So, and I wanted to share, so that's why we're here. These actions, okay, so let's go back over that. When hearing quasi in rem actions, a court may only affect a named defendant's interest in a specific named piece of property. These actions have similarities with both in rem and in personam actions. As is the case with in rem actions, a court may hear a quasi in rem action if the named property is within the court's jurisdiction, which it is, right? When there's a certificate and it's in the states and you're in a county court, which makes it a lot better too in the United States if you're in a federal court, because the certificate doesn't show that the property is in the United States. It shows that it's in a state. The United States only exists in the 10-mile square. So let's go back to the beginning of that sentence. As is the case with in rem actions, a court may hear a quasi in rem action if the named property is within the court's jurisdiction, even if the court does not have the power to exercise in personam jurisdiction over the defendant. All right. This is why they try to lock you in to that jurisdiction by asking you questions to tie you to the property to take that in rem jurisdiction, so they can take jurisdiction over your person in personam. However, a court acting quasi in rem may only affect the interests of a single named defendant, as is the case in an in personam action. Okay, so in other words, it can't name a bunch of defendants under one piece of property, so to speak, or under one quasi in rem jurisdiction. There are two types of quasi in rem actions. In a quasi in rem subtype 1 action, a plaintiff may sue to enforce a pre-existing interest in the named property. For example, a lender might use a quasi in rem subtype 1 action to foreclose a mortgage. All right, now that's subtype 1. The state can't sue subtype 1 because they would have to prove their interest in the property, right? It's basically what that just said. So a lender is going to go, well, I can prove my interest in the property because I've got the note or the copy of the note. We know how they do, all that kind of stuff, right? So that would be subtype 1 quasi in rem, is how the court is taking jurisdiction over you in a mortgage case. I mean, they just said it right there. Quasi in rem subtype 2 action is more complicated. In this type of action, a plaintiff may sue to apply the named property to satisfy his or her claim against the property's owner where the plaintiff's claim is unrelated to the property. That sounds like our state actions, right? So now we just heard how they get us into the mortgage action. Now we hear how they get us into the state action, okay, or lawsuit, if you will, another word for action. This type of action is technically against the named property, not the property's owner. Interesting. Thus, the outcome of the case is final regarding the plaintiff's claim against the named property and does not affect the plaintiff's future claim against other pieces of property or the property's actual owner. Okay? So the outcome of the case is final regarding the plaintiff's claim. So if you shut them down, in other words, they have to start another case if they were going to pursue the same issue, right? Res judicata, basically. For example, an American plaintiff injured by a reckless driver while vacationing in a foreign country might use a quasi-in rem subtype 2 to recover from the driver if American courts could not obtain personal jurisdiction over him. Just an example, but it still fits. Courts may not exercise quasi-in rem subtype 2 jurisdiction where it would be unreasonable to do so. So this is it, man. I mean, this is basically how they're, taking their jurisdiction over you, and why when you go in there, it's very important not to allow them to create that connection between you and the property. It's also super important why we are trying to help people understand how to take interest in the property. Once you have that bona fide interest in the property, okay, or that substantial claim on that property, and you can show the interest as recorded in the county, which is why you'll see myself, guys like Divergent 5, KL, like we talk about your public record is super important. When you take interest in that property and you have the superior claim, which is what people call a UCC1. A UCC1 is not a lien for people who are new to the UCC SPC thing. It's not a lien. You have to have a security agreement. You have to have interest in the property. However, a UCC1 is just a notice of interest. That's all it is. It's a notice, period. It's not a lien. Okay, it's a notice of lien. Just like when the IRS puts a notice of lien in the county court for taxes, that's just a notice of lien. That's not the lien. The lien is the security agreement. The lien is the agreement that I'm going to give you collateral in return for a loan. So that's the lien. The lender has the lien on my property because I agreed to give him the interest in the property. Well, when we do this in the county record, you don't need a UCC1 for your straw man. You can do it in the county record, and it's just as effective in equity. Okay, so an interest recorded in the county, or even a notice of interest. Number one, you have an agreement, then you put a notice. You could put a notice of interest in the newspaper. You could put a notice of interest in the county. It's the same thing as a UCC1 and has just as much power and effect. Okay, it's just a notice of interest. So once that notice of interest is perfected, and you've accepted the gift, the certificated security, the entity that was given to you at birth, that was created at birth, and then you failed to perfect it, you failed to accept it. Once that's done, and you have that perfected interest, it's harder for them to take quasi-in rem subtype 2 jurisdiction because you've got the interest rate, the record of interest right here, along with the security certificate itself. So that's really dangerous for them because now they don't have any fictional way to take jurisdiction over you, only the property. And that's what's so important in terms of these court cases and these court hearings, okay? However, you can give them jurisdiction right away, and now you're screwed because you get, well, how am I going to show interest in this property now? Then you got to hurry up and try to backstep if you lock yourself into that jurisdiction by answering the questions wrong or whatever these little gatekeepers games are that they try to play. So that's why I always say, we never give information. We don't give a name. We don't sign anything because we're not giving any jurisdiction over. So it's really, really important to withhold that card, right? Because you don't want them to have that jurisdiction card if it's one of these, bullcrap cases. Okay, so the securities are really, really important. Like I said, there is a so somebody put, let me read this real quick that Jacob Daniel put in the chat here. The term minor is also used to refer to an individual who has attained the age of 18 years but has not yet taken control of the securities contained in his or her minor account. Okay, so that's it right there. So you're taking control of those securities, okay, by having your interest. Then from there, you can notify Secretary of State, you can notify whoever you feel you need to notify. The securities intermediary, which would be the Federal Reserve, the Treasury is another securities intermediary. The court is a securities intermediary. If they're creating an account and they have your name on it, right? Your name is on the account. Just read the definition of securities intermediary under UCC 8102, the definitions. It'll tell you what securities intermediary is. Okay, so 31 CFR 363.6. Thank you, Jacob. I appreciate that. That is telling you right there, that the reason you're a minor is because you haven't taken care of the securities. So that's the game, man. I mean, take care of their securities. That's why when I wrote my declaration of status, I made sure I had power of attorney, right, which gave you the authority to act. Then I was very thorough, and it's got 80 points in it. And then I turn around and I also claim my interest in it, and I show in my declaration of status why I have interest, because I've funded this thing, because I have over 21. I like to use over 21 silver dollars for solvency, that I have funded this thing, okay, or can fund this thing, and therefore I have interest in it, and this thing owes me all of its collateral for that. So I have in my declaration of status the actual, if you will, security agreement. Now, let's not get confused with investment security agreements. So when you see people doing security agreement for the UCC stuff, okay, and it says security agreement real big on it and all, that's for investment securities. Investment securities that are registered securities and stuff, yes, you have to have the word security agreement, and you have to go through certain protocol for the security agreement. These are not investment securities. These are public securities, okay, meaning the public owns them at first, or issues them, I should say. But they're not investment securities. So for me to take an interest in it, I don't have to go through a investment, like a security agreement drawn under the UCC, because that's for investment securities, people that are getting into the trade game. All right, I'm not doing that. So I can take interest in it in one simple paragraph in my DOS, okay, and then what I do is I do my acceptance and acknowledgement of the certificate. Then I do my notice of interest based on that paragraph. I also appoint myself general executor, so I'm exonerated from the claim, and I can enter the court as a general executor with power of attorney if I want to. And then I always do a notice of adverse claim, which your adverse claim you can do to any individual that or person that is, trying to attack you based on that minor status. You can then do your adverse claim and say, hey, I've got an adverse claim here. Well, my thinking was, if it's already recorded in the county, it's already done. All you do is just, here you go, bam, here you go, adverse claim. You're gonna step up and say you got a priority claim in this, because you can't have a priority interest, because I'm the only one on record with a priority interest, unless you could pull one out somewhere. Is it in the newspaper somewhere? Is it in a court? Is it in the UCC? Show me someone's priority interest in this thing. Show me the United States priority interest in this thing. If you can't, then you got no claim. I'm first in line, first in time. So that's why my DOS and POA is so thorough, because it says everything that, at least I tried to think of everything that it needed to be said. And for those people that are interested in my template, purchasing my template, you're more than welcome to. You can add, delete, whatever you want to it, but it's thorough. There's like 80 points in it. Unless you're not married and you don't have children, it cuts it down to, I don't know, like 60 points, something like that. But it's really thorough, and the exhibits are really solid. And the reason I use a power of attorney, not the only reason, but one of the reasons I use a power of attorney, is because it is a vehicle to get the declaration of status recorded. because most county land records, land deeds, they won't record any other documents other than the ones that they are statutorily authorized to record. And just about, every county land records is authorized to record a power of attorney. So the power of attorney not only gives me the power to speak on this thing's behalf, or do certain legal maneuvers with it, if you will, it also provides a vehicle to get that recorded into the county. So that's why I use that setup the way that I do. All right. So from there, the world is your oyster. I mean, you notice people, you got to think about who you are in the mix of the entire thing as the securities holder, right? As the securities entitlement holder. Look that definition up. That's another thing. Go to UCC 8-102 or 8-102. That's the definitions for securities. Again, though, keep in mind investment securities. However, equity is all through the Uniform Commercial Code. So when you read the definitions, you're not so much concerned about it in terms of investment securities. You're just trying to get the essence of what these terms mean in relation to securities. Because even though the UCC is for investment securities, it is still, the essence of the words are still applicable to this public security. So I go to the UCC Article 8, Section 102, and I look at the definitions to understand who the players are in this whole game. I'm like, oh, well, bam, it says right there, securities intermediary is a bank, or and I'm paraphrasing, but it's a bank. It's someone that has an account, a securities account with your name on it, essentially. And then it says, basically, it's the Federal Reserve, right? That's one. The Treasury would be another. The court would be another. Anybody dealing with the securities that's opening an account, which a court case is an account, they're an intermediary at that point. Okay, so you.
All right, so we're going to stop there and just give you the basic on how they are taking jurisdiction over your property that they call taxes. Now, that being said, you're the owner. You don't per se have a house payment. Okay, you can still wiggle through there and get the security MRAM jurisdiction part of that. But in general, this is what they are doing. And technically it's fraud. They're just doing good business and all that. But when you go by the Constitution and codes and statutes, rules and regulations, cannot oversee the Constitution, but they threw all these little mixtures in it, right? Which makes it really hard to find and get your Constitution and your property back, because they hidden it so well, right? So this is one of the kind of the things you need to think of when they are confiscating your property for behind taxes or whatever. Okay, this is how they're attached to your property with that MRAM jurisdiction said Title II. Okay, so to know that, you can kind of fight back on it. All right, this is Diesel We the People News. I'm gonna stop it here. But if you want to watch the rest of the videos, or leave me a comment and say, hey, can you record the last part of this? Because it's pretty long, obviously. It's called Robert. Okay? You guys read it on the side there. Just probably type all that in there. Maybe you'll get it. Again, I still haven't done that ping thing. Okay? So my apologies. Anyway, these will be the People News. All right? Remember, y'all, never, never, never just look straight forward. Always look around you, be able to protect yourself by any means necessary. According to my research, y'all, whether you go by legalese or whether you go by, the way this guy operates, or whether United Nations people and all that kind of stuff, they're all have their own special deals operating in the United States. Okay? But there's just certain things that you got to be particular of, or you may or may not go to jail. I don't know. This is We the People News. Bye, y'all.